My name is Hannah Sells, Litigation Counsel for the Freedom Foundation. I'm honored to have with me today Senator Michael Baumgartner, Ranking Republican Member of the Senate Labor and Commerce Committee, as well as Representative Brandon Vick of the 18th Legislative District. On June 27th, the United States Supreme Court issued a game-changing decision, Janus versus AFSCME. That decision articulated First Amendment rights that the Foundation has been advocating for years. It is a strongly written command to the states to protect the rights of workers. However, that decision is only impactful if it is followed. That's why we're here today. Today, the Foundation submitted a letter to the OFM and the Governor's Office explaining the impact of Janus and what we expect to and will insist upon seeing change in the state's practices going forward. Janus commanded several changes. First and foremost, it held that all funding of public sector unions must be voluntary. This means that the practice of forcing public employees to pay agency fees to a union is illegal and must end immediately. Secondly, to protect workers from that forced funding, the court held that the state must have prior affirmative consent to deduct any union funding from employees' paychecks. This puts an end to the opt-out schemes that many unions and states have employed across the country. Now employees must opt in to a union, but no dues may be deducted before they choose to do so. This leads to the final point. Janus made clear that an agreement to pay union dues is not a simple financial transaction, but rather a waiver of a constitutionally protected right. This holding has monumental implications. A waiver of a constitutional right must be informed. It must be made knowingly, clearly, and voluntarily. Before Janus, workers were told that paying union dues was a prerequisite for state employment. But how could an agreement made in those circumstances be knowing or voluntary? It could not. And therefore, any membership agreement, consent form, any document purporting to give the state authority to deduct union funding of any kind from an employee's paycheck is invalid unless it was signed after Janus. Let me be clear. The state may only deduct funds from employees who consented to union funding after June 27th, 2018. Today is the first payday for state employees since Janus. We don't know yet if the state followed Janus. We don't know yet, but we will find out. We will protect the rights of Washington's public servants. And today we put the state of Washington and its public sector unions on notice. This is the law of the land, and you must follow it. Whether you do so now or after a court battle is your choice. Before I take questions, Senator Baumgartner has a few words to say.
Well, thank you very much, everyone. I'm Senator Michael Baumgartner from Spokane. I am the ranking Republican of the Senate Labor and Commerce Committee. For 3 years, I was the chairman of the Senate Commerce and Labor Committee. This is a great and important day. I applaud Freedom Foundation for the hard work they are doing to inform public sector workers in the state of Washington and across our great country of America of their rights that have been restored under the Janus decision. Make no mistake, the Janus decision was a very clear decision. It was not a decision of gray area. It said clearly, and if you read Justice Alito's ruling on Janus, it was very clear that there must be affirmative consent. Starting anew, affirmative consent if the government is going to forcibly, unions are going to forcibly take money out of state employees' paychecks. Now, we know in this state, that many of the Democrats that run the state of Washington are essentially puppets of organized labor bosses. Both Governor Jay Inslee and Bob Ferguson, our Attorney General, largely owe their positions to mandatory forced union donation money. So we are under no illusions that as Freedom Foundation and others make this demand that Janus be enforced, we are under no illusions that it will be easy in this state. But today, I will be delivering a letter to Attorney General Bob Ferguson, demanding that he enforce the Janus decision in this state that union donations are not taken without affirmative consent. Last week, Senate Republican leader Mark Schessler delivered a letter to Jay Inslee saying the same thing, that there must be new affirmative consent before union donations are taken. And this is not just about politics. This is about essential freedoms under our Constitution. It has gone to the highest court in the land. And one of the, in addition to this being just a great day for these workers to be able to keep more of their hard-earned money in their pockets, we are also going to expand the state workforce pool of applicants to a greater and more diverse array of state workers. I know of several people who have considered employment with the state, but have decided not to apply for those jobs because it violated their conscience to know that their union donations would be taken by state employee unions and put to political purposes. So we're going to get a broader and deeper array. And I would say that after 3 years of holding hearings on union issues, that there will be every attempt made to confuse the issue, to hide the issue, to say that previous pieces of paper that were signed in secret or without full knowledge will count. That is not so. And if you just look at what happened last year in the most recent legislative session, when on behalf of the state employees union, SEIU, the Democrats that controlled the state legislature for the first time in 6 years passed a bill to create a fake public sector union as a workaround to the Harris versus Quinn decision. So we already know how this is going to go. There was uncovered a confidential document to the governor written specifically by SEIU boss David Rolfe saying, here's the 7 ways we want you to get around Harris versus Quinn. That was discovered through a public information request. And then lo and behold, the Democrats ran a bill that looked exactly like that. So at great cost to the state, a fake private sector union was created to subvert another Supreme Court ruling, Harris versus Quinn. So I would expect the same thing will attempt to be happen this year, but the Freedom Foundation is ready. Legislators are ready to shine a light on that. Hopefully the press is ready to shine a light on what is happening in the state. It's gone on too long. With the Janus decision, it comes to an end. So this is, again, a very great day, not just for the workers, public sector workers of the state of Washington, but for all the people of the state of Washington. Thank you very much.
Well, it's a great day for public sector workers, and it's a great day for the Freedom Foundation, and we look forward to serving the state of Washington going forward. Thank you.
Thank you very much. There we are.